Welcome to the Sanders Standard, where we examine law, power, and accountability without sanitizing the facts. I'm Eric Sanders, joined by Maya Bennett.
Great to be here. And for you listening, today we are taking a really raw, unvarnished deep dive into a fierce legal battle that recently unfolded in the New York State Supreme Court.
Yep, it's a complex one.
It really is.
Yeah.
So I want to lay out exactly what we're looking at on the table today. We have a stack of primary source documents. We've got a decision and order handed down by the Honorable Carol Sharp on December 17th, 2025.
Right.
We also have a remediator from the Appellate Division dated June 16, 2026, and the affirmation in opposition filed by this law firm, alongside a sworn affidavit from retired NYPD Deputy Chief Winston M. Faison.
Those documents, they basically form the entire architectural blueprint of this whole dispute.
They absolutely do. But before we unpack them, I need to be entirely clear with you right out of the gate. These documents contain intense, highly charged allegations involving race, police misconduct, and institutional corruption.
It gets heavy.
Right. So our mission today is to impartially break down the facts, the mechanical discrepancies, and the legal arguments precisely as they're presented in these court filings. We are here to analyze the machinery of this case, not to endorse any specific political viewpoints.
The machinery is actually what makes this so fascinating, because the inciting incident, like the spark that lit this entire fire, seems incredibly trivial on its face.
Yeah, let's look at that spark. So the center of the initial conflict is Vladimir Ravich. He's a white male NYPD sergeant in the aviation unit, and he sued the city and deputy chief Winston Faison, who was the black commanding officer of that unit at the time.
Claiming race and disability discrimination.
Exactly. But the legal maneuver we are dissecting today didn't actually argue the merits of those discrimination claims at all. Instead, Ravich's attorney, John Scola, filed an order to show cause to completely disqualify this firm from representing Deputy Chief Faison in an entirely separate, unrelated matter.
Which is just, to understand the sheer audacity of that motion, you have to look at the legal standard it was attempting to exploit.
Right, Rule 1.1.
Exactly. Rule 1.18c of the New York Rules of Professional Conduct. Disqualifying an attorney based on a prior consultation requires meeting an exceptionally heavy burden. It's not easy.
What do you actually have to prove?
You have to prove two very distinct elements. First, that the new representation is in the same or a substantially related matter. And second, and this is the most important part, that the attorney received confidential information that could be significantly harmful to the prospective client in that specific matter.
And, that standard exists for a very practical reason. You can't just call up every top-tier law firm in the city, talk about the weather for 5 minutes, and then claim a lifetime conflict of interest to prevent your opponents from ever hiring them.
Exactly. There has to be actual weaponizable material exchanged.
Right.
And when you look at the factual reality of Ravich's intake call, it was completely disconnected from the narrative presented in his motion. According to the affirmation filed in opposition, Ravich's brief inquiry, which happened months prior to his lawsuit, had absolutely nothing to do with Deputy Chief Faison.
Nothing at all.
Nothing. It had nothing to do with federal corruption probes or unit-wide conspiracies. The conversation was focused entirely on Ravich's dissatisfaction with how the NYPD's Office of Equity and Inclusion handled an accommodation request for his office lighting.
Wait, his office lighting?
Yes. The documents indicate he had sustained a head injury in 2021, and he specifically wanted red lights in his office instead of standard fluorescent lights.
Okay, so it's like a sports team trying to get the opposing team's head coach banned from the championship game by claiming he stole your secret playbook, when in reality, all you actually handed him was a Post-it note complaining about the locker room thermostat.
That is the perfect way to visualize it. It was a rudimentary timeline regarding a lighting accommodation. That's it.
So no big secrets.
No medical records exchanged, no sensitive financial data, no high-level confidences. Based on standard professional judgment during that intake, the claims didn't appear viable or, frankly, made in good faith. Because of that, no retainer was ever dined and no attorney-client relationship was ever formed.
Which is pretty standard.
It is. Standard practice dictates that notes from unconsummated rejected intakes are destroyed to protect everyone involved, which is exactly what happened here.
But the plaintiff side tried to push the narrative that a relationship did exist.
They did.
Except the affirmation points to an August 14th email from Ravich himself that completely torpedoes that argument. In it, Ravich explicitly states, and I'll quote this, "I was under the impression that you may not have had the interest in taking my case." And he confirms he retained John Scola instead.
He even offered to assist as an outside contact on other cases.
Right. You do not offer to be a helpful outside contact to a lawyer you believe is actively representing you as a client.
The contemporaneous written record proves the exact opposite of their claim. No relationship existed, and no significantly harmful information was exchanged. Honestly, if this were merely a misunderstanding of a legal standard by an overzealous attorney, the judge would simply deny the motion and everyone would move on.
But that is definitely not what happened.
Far from it.
When you read Judge Carol Sharp's December 2025 decision and order, the focus shifts from a debate over legal standards to something much darker, which is the integrity of the evidence itself.
Yeah, this is where it gets troubling.
The documents submitted by Ravich's side raised massive, glaring red flags. The emails submitted to the court as Exhibit A were materially different from the scanned PDF versions submitted later. And both of those were materially different from the actual emails eventually forwarded directly to the judge's chambers.
And we are talking about foundational evidence here, submitted under the penalty of perjury to secure emergency relief.
Right.
The discrepancies weren't just minor clerical typos. The court's order details how an entry labeled blank 13.docs mysteriously appeared in the Exhibit A filing, but was entirely absent from the other versions.
Just completely gone?
Completely gone. And when the judge reviewed the actual emails forwarded to chambers, there were missing attachments, documents titled background.docs and complaint.docs, that didn't align at all with the page listings in the PDF submission.
How does something like that even happen? You're submitting the same email chain 3 different ways, and attachments are vanishing and appearing like a magic trick.
It completely compromises the court's ability to trust the filing. It strikes at the very truth-seeking function of the justice system.
And when an attorney is confronted with those kinds of impossible discrepancies, the instinct is often to hide behind confidentiality.
Which leads to a truly fascinating legal mechanism detailed in the Appellate Division's remitter. That's the official document where the appeals court sends its final ruling back down to the trial court.
Yeah, let's unpack that.
When Ravich's counsel realized the emails were under intense scrutiny, he suddenly attempted to claim they were protected by attorney-client privilege.
It is a stunning contradiction. I mean, you cannot claim that a document is a highly guarded, privileged secret while you are simultaneously stapling it to a public court docket to smear opposing counsel.
Exactly. This is what the courts call an at-issue waiver. Think of privilege as a shield. You are allowed to use that shield to protect private conversations with your lawyer.
Makes sense.
But you cannot forge those private conversations into a sword, use it to attack your opponent in a public filing, and then suddenly pull up the shield the second the judge asks to inspect the blade.
That's a great analogy.
By affirmatively placing those communications on the public docket to support a motion, the court ruled they completely forfeited the privilege.
And the rulings were unequivocal. Both Judge Sharp of the Supreme Court and the Appellate Division unanimously denied the disqualification motion. But Judge Sharp was so disturbed by the doctored evidence that she invoked the court's inherent power to protect the judicial process.
She had to.
She didn't just deny the motion. She ordered a specific mandatory hearing on the potential misconduct surrounding those altered emails, scheduling it for January 14th, 2026.
And that mandatory hearing forces us to look beyond the immediate paperwork and ask a really fundamental question. Why? Why would anyone go to such extreme lengths, risking judicial sanctions and doctoring evidence over an intake call about red office lights?
Right, it doesn't add up.
It doesn't. The context provided in the documents suggests this motion wasn't really about a lighting accommodation at all. It was a targeted strike. And to understand the target, we have to look at the historical culture of the NYPD's aviation unit.
The affirmation provides a deep, independent knowledge of that unit's toxic internal culture. Knowledge that predates this specific plaintiff by over a decade. The firm had previously represented Detective Fernando Angel Argote back in 2011.
He wasn't just a pilot either.
No, he was a highly credentialed expert helicopter mechanic.
And he blew the whistle on some terrifying systemic safety issues. Life-threatening issues that the institution frankly wanted buried.
What did he find?
Detective Argote identified excessive tail rotor play on a Bell 412 helicopter. Now, for those unfamiliar, the Bell 412 is a heavy-duty aircraft actively used for air-sea rescue and counterterrorism missions.
Serious machinery.
Very serious. Tail rotor play means the mechanisms controlling the helicopter's anti-torque system are dangerously loose. If that fails mid-flight, the aircraft uncontrollably spins out and drops from the sky. Grounding that aircraft is a mandatory federal aviation protocol.
So he did his job and flagged a fatal mechanical flaw. How did the unit respond?
Instead of fixing the helicopters, his supervisors accused him of not being a team player. They removed him from the maintenance floor and banished him to guard duty.
Oh, wow, guard duty.
Yeah. The culture dictated that grounding an aircraft for legitimate, documented mechanical defects was treated as an act of insubordination. It was a clear message to everyone else in the unit: keep your mouth shut or your career's over.
That establishes a culture of severe retaliation against safety reporting. But the filings outline something even deeper, which is a structural, decades-long pattern of exclusion based on race.
Going all the way back to 1988, the affirmation cites the case of Veronica Funchess. She was a black female police officer who held a valid pilot's license. Despite being objectively qualified on paper, she was repeatedly, systematically denied entry into the aviation unit.
For decades, it was an open secret within the department that black officers, regardless of their flight hours or credentials, simply could not break through the institutional blockade into that specific command.
That decades-long blockade is exactly what makes Deputy Chief Winston Faison's arrival so disruptive.
Yes. When you look at Faison's affidavit, his credentials aren't just good, they are staggering.
Truly.
He holds Federal Aviation Administration airman certificates as a commercial pilot for both airplanes and helicopters. He is a certified flight instructor. Yet, when he finally shattered that ceiling to become the first black commanding officer in the history of the aviation unit, he describes facing immediate, coordinated institutional resistance.
His affidavit states he became the target of a coordinated effort to undermine his leadership and erase his accomplishments from day one.
Which brings everything into a terrifying kind of focus. If Faison is trying to reform a unit that has historically punished whistleblowers and excluded minorities, and he hires a law firm with a proven track record of exposing that exact systemic exclusion, is this disqualification motion just a weapon?
Absolutely.
Are we looking at a situation where civil litigation is being hijacked to wage a proxy war against diversity in leadership?
That is precisely what the sworn filings allege. The disqualification motion had nothing to do with protecting a former client's confidences. It was a tactical maneuver designed to sideline the very counsel who knew where all the institutional bodies were buried.
Wow.
And the affirmation doesn't just make that claim in a vacuum. It backs it up by exposing the documented history of the plaintiff's counsel, John Scola, outlining a very specific, highly destructive playbook.
And that playbook is really the climax of this deep dive, because if the allegations in these filings are accurate, this isn't just aggressive lawyering. It's a coordinated pattern of weaponizing the justice system. The most explosive example detailed in the affirmation is the David Terrell case, which the media heavily branded as the Monster Cop saga.
The Terrell case is a masterclass in how civil litigation can be manipulated to destroy an effective investigator. David Terrell was a black detective who successfully investigated and dismantled massive narcotics and weapons trafficking networks in the Bronx. We are talking about violent street gangs like the Lyman Place Crew and the Hilltop Gang.
Led by a figure named Pedro Hernandez, right?
Yes, Pedro Big Bank Pablo Hernandez. And usually when you take down a criminal network of that size, they fight back in criminal court. But the affirmation outlines a completely different strategy here.
Right. Between 2015 and 2018, Scola, working alongside a disgraced former officer turned private investigator named Manuel Gomez, just flooded the civil docket. They filed approximately 22 civil rights lawsuits against Detective Terrell. Yeah. But these weren't brought by random citizens. They were filed on behalf of the very violent gang members Terrell had arrested.
Wait. If an attorney files 22 lawsuits on behalf of known gang members against the cop who arrested them, doesn't a judge instantly see through that? How does filing a barrage of civil suits actually help a gang leader like Pedro Hernandez?
It's all about creating leverage and reasonable doubt. When you file a civil rights lawsuit alleging police brutality or corruption, it instantly creates what's known as Brady material.
Ah, I see.
Defense attorneys can use those pending civil allegations to cross-examine the detective in criminal trials, painting them as a corrupt rogue cop to the jury. It ties the officer up in endless depositions, drains their resources, ruins their credit, and fosters jury apathy. The goal is to force acquittals for violent offenders by destroying the credibility of the arresting officer.
And they amplified that leverage through the media. The affirmation notes they coordinated with figures at PIX7 and NBC to broadcast these unverified civil complaints as absolute fact, effectively convicting Terrell in the court of public opinion before he ever set foot in a courtroom.
But the entire house of cards eventually collapsed. Every single one of those 22 lawsuits was ultimately dismissed.
Every single one.
And the judicial vindication for Terrell was absolute. The Supreme Court in Queens County actually held a SIRA hearing in the case of People v. Ajayanili.
Let's define that for the listener because it's crucial. A CRA hearing is a highly specialized legal proceeding in New York used specifically when there is an allegation that a witness has been intimidated, coerced, or tampered with so they won't testify truthfully.
Exactly. And during that hearing, the court explicitly condemned Manuel Gomez's actions. The judge found that Gomez had conducted a sham investigation, utilizing deception and false promises to coerce a key eyewitness into recanting her identification on television just one day before a murder trial.
It's unbelievable.
The court formally ruled it an intentional effort to obstruct justice and tamper with a witness.
But the affirmation lists other cases to prove this wasn't an isolated incident with the Terrell case. There is the Trevlin Headley case, where Scola filed a lawsuit falsely accusing Detective Shatora Foster, a black female officer, of sexual harassment.
Wait, falsely accused her?
Yes, because when you look at the verified answer and the internal records, they established that Detective Foster was actually the victim of forced sodomy while on duty at one police plaza.
That is just, it is the deliberate inversion of reality. You take a victim of a horrific assault and you file a public pleading accusing her of being the sexual predator, literally rewriting public memory before the truth can come out at trial.
We see the same inversion in the Thomas G. Donlan case, involving a whistleblower named Lieutenant Quathisha Epps. The affirmation states Scola's verified complaint fabricated a completely non-existent FBI raid on Epps's home.
A completely fabricated federal raid.
Inserted into a public pleading, seemingly for no other reason than to portray a black female whistleblower as the target of a criminal probe. It is a calculated, systematic misuse of the judicial system. You manufacture allegations, file them on the public docket, and use the media to launder those allegations into accepted facts to discredit individuals who expose high-level corruption.
Which brings this entire historical playbook crashing right back into Deputy Chief Faison and the aviation unit. If you look at the timeline, it is chillingly familiar.
Yeah, tell me about the timeline.
Well, in July, August, and November of 2025, a series of suspiciously timed, anonymously sourced hit pieces appeared in the New York Post. These articles mirrored Scola's legal filings word for word. They utilized highly racially charged rhetoric, accusing Faison of favoring black cronies and running an unsafe unit.
The exact same unit that historically punished people like Detective Argout for actually reporting safety hazards.
Exactly. And the November article was published on the front page right as this disqualification motion was pending. It even quoted Scola directly. It is the exact same playbook used against Detective Terrell.
File sensational claims, orchestrate media leaks, and then, when the target hires effective counsel to dismantle the smear campaign attempt to disqualify or intimidate that counsel.
That's it.
Deputy Chief Faison retained this firm specifically because of our experience in exposing these coordinated reputational attacks. The motion over the red office lights was nothing more than a tactical illusion designed to strip him of his defense.
And that is what brings this entire complex journey into sharp focus for you, the listener. What began as a highly technical legal debate over a Rule 1.18 conflict of interest, wrapped up in a story about fluorescent office lights, is actually a profound battle over the integrity of the judicial system itself.
100%.
When public court dockets and media access are weaponized to silence whistleblowers, to protect systemic exclusion, and to deliberately sideline effective legal counsel, it doesn't just harm the individuals involved. It severely damages the public's fundamental right to transparent, accountable institutions.
If you are a practicing attorney and subjected to similar collateral attacks, get in touch with the Sanders firm, PC, at 212-652-2782.
I want to leave you with a final thought to mull over today. When public dockets and anonymous media leaks become synchronized tools for reputational warfare, who is actually policing the truth? If the justice system's own mechanisms, its rules of professional conduct, its temporary restraining orders, its claims of confidentiality, can be hijacked to protect entrenched corruption and penalize diversity, we have to ask ourselves, how much of what we read in the daily headlines is a genuine scandal, and how much is just a carefully orchestrated legal illusion?